Welcome to the Brigham Young University Family History Library webinar series. Feel free to use the chat box for any questions during the presentation. If we are unable to answer them during the presentation, they will be answered at the end. My name is Maddie Acey. I will be your host for this webinar. Today, we will be pleased to hear from Peter Midgley, who will be giving a presentation titled Copyright Essentials for Genealogists. Peter Midgley is the director of the BYU Copyright Licensing Office. He is a registered patent attorney with a degree in electrical and computer engineering from BYU and a law degree from the George Washington University. Before coming to work at BYU, he practiced intellectual property law for 15 years at law firms in California and Idaho. He presents frequently on copyright topics as well as other intellectual property topics, including patents and trademarks.
Thanks, Maddie. I appreciate that, and happy to be here. So I'm going to cover, hopefully, what is a complicated topic in a way that's accessible to everybody, because I know as genealogists, we don't have an occasion to think about copyright too frequently. So the way that I've organized this presentation is around 5 key questions. And the first is what is protected by copyright to begin with, and we'll go through each of these individually. The second question is, if you're dealing with subject matter that is copyright protected, who is it that owns the copyright? Third, when does the copyright protection expire for a given work? The fourth question is, how can you go about using works safely without fear of getting sued for copyright infringement? And then fifth, why do we need to worry about this at all? And we'll cover a few case studies as we go along to look at instances where copyright owners have asserted their rights in various contexts related to genealogy and family history. So the first question is, what is protected by copyright? And to answer this question, we'll start with the basic foundations for copyright law, which come in this country from the founding document, the Constitution. And as you can see here, Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So from the very early days of the country, at its very founding, the founding fathers recognized this need to provide some protection for inventors and authors. And so it's been around, for really since the very beginning of the country. And Congress has enacted these 5 different copyright acts in our nation's history. So starting in 1790, the very first one, and then as you can see those dates there going up until our current act, which was enacted in 1976. So the people in the copyright field understand that the world has changed quite a bit since 1976. And so it might be kind of fun to just take a look at what the world looked like back in 1976 as Congress was adopting what is our current copyright law. So I prepared a little time capsule here for the various technologies that were in place, starting with copiers, photocopiers. We have here some audio equipment. This is what audio and stereo equipment looked like in 76. Instant photography, those of you who are old enough to remember Polaroid cameras. Computers looked quite different in 1976. Here's a picture of a very modern looking computer. This one is my personal favorite. This is what the DVR looked like in 1976. A Sony Betamax machine. The point of this little trip down memory lane is to remind everybody that this is the way that the world looked to members of Congress at the time they were enacting what is our current copyright law. So, in the year 2016, when the world looks quite different and we have all kinds of devices, mobile computing devices that allow us to capture content wherever we are, to consume content in huge quantities and broadcast it out to millions of people. These were all concepts that were totally unforeseen and unforeseeable really in 1976. And so we keep finding ourselves in situations where the law that's now 40 years old we have, it's increasingly difficult to apply it in certain situations because it just wasn't written with modern technology in mind. Be that as it may, this is the current law, and copyright basically protects any original work of authorship that's fixed in a tangible medium of expression. And importantly, there is no requirement that you register your work with the U.S. Copyright Office. So this is a major difference from patent or trademark law, where you need some sort of government body to approve an application. In the world of copyright, you have a copyright interest at the moment your expression is fixed in a tangible medium. So in the photo that accompanies this slide, you can see whoever it is that's writing that text, they have a copyright as soon as their pen comes off the page. If you're typing at a computer, as soon as your fingers come off the keyboard, you have a copyright. You don't need to wait. If you snap a photo with your phone, you have a copyright in that. Again, you don't need a government agency like the U.S. Copyright Office to tell you that you have a copyright. You have it at that moment in time. So the various categories in which you can get copyright protection, we start with literary works, novels, poems, lyrics, those sorts of things. Musical works, obviously those are, if you're a songwriter or a composer. Dramatic works would encompass things like plays or movies. Yeah, even pantomimes and choreography are eligible for copyright protection. We have pictures and graphics, so for either photos or drawings or paintings. Motion pictures actually gets its own specific category. We have sound recordings as well as architectural works. So those are the 8 categories of works that are recognized in the statute that are eligible for copyright protection. I wanted to provide some examples in the context of genealogy for things that most genealogists seem to be interested in. So obviously things like photographs, whether it's family photos, wedding photos, those kinds of things, those are covered. Letters are covered. It doesn't have to be a full novel to be eligible for copyright protection. A simple handwritten letter is copyright protected. Diaries, your pioneer ancestor who jotted down their memories or thoughts in their diary, that's a copyright protected work. Obituaries is another category that a lot of genealogists are interested in, and we'll get into who owns the copyright, but it's important to recognize that an obituary, there's enough text there that it is protected by copyright. So some things that aren't covered would include any basic ideas or facts. So for example, things like census data, those are just facts and figures. Who was born in what year, how many people were in a particular family, those sorts of things, that's not covered by copyright. If you have any military records, government records of the United States federal government are all in the public domain, so none of that stuff is covered by copyright. If it's, again, just basic biographical information, birth dates, death dates, marriage dates, anything in that realm isn't covered by copyright at all. So if you're dealing with records in that space, you don't need to worry about the copyright implications. The last thing we're going to cover here are the exclusive rights that are enjoyed by copyright holders. The first is the right of reproduction. So if you own the copyright in a given work, you are the only person who can make additional copies of that work. You also have the right to prepare derivative works. So that could be a translation from English into some other language or vice versa. Those would be derivative works, and you need the copyright owner's permission to do any of that kind of work. Distribution includes publishing and making works available online. Any kind of public performance, if you're trying to make use of a song, let's say in a family history video with photos that you might have, and you want to publish that information, that would constitute a public performance of the song. So background music in the back of wedding videos or other sort of commemorative videos, that's a very popular thing, and that there are definitely copyright implications for all of that. Or the public display of work. So again, this happens mostly in the field of photos or artwork, where you might publish or post that information online. Any of that kind of stuff is the exclusive right of the copyright holder. So we have a case study here that I wanted to go through just to illustrate how this works in a specific example. It's a pretty early case. It's from back in 1912, so it's before our current copyright law, which was enacted in 1976. But it illustrates, I think, nicely these points we've been talking about. In this particular instance, what we had was some letters, some handwritten letters that were written by Mary Baker Eddy, who was the founder of Christian Science. And an auctioneer had come into possession of these letters and wanted to sell them at auction, which is perfectly fine. But in order to do that, the auctioneer wanted to reproduce some of the letters and publish them in advertising materials to garner additional interest in the auction. And the executor of Mrs. Eddy's will sued the auctioneer for copyright infringement. And the court in that case ruled in favor of Mrs. Eddy's estate. And this is the quote that's now a very famous quote in the space of copyright law. The recipient of a letter can deal with it as an absolute owner, subject only to the proprietary right retained by the author to the publication or non-publication of ideas in its particular verbal expression. So in a case like this, if you are in physical possession of a handwritten letter or diary of one of your own ancestors or somebody else, then you can use that as personal property. You can cherish it. But if you want to make additional copies, for whatever reason, you're going to need the permission of the copyright holder. Now, if it's your own ancestor, you may be the copyright holder. We'll turn to that question in just a second. But this case illustrates that just because you happen to have physical possession of an object does not give you the right to make additional copies for any reason. That's the fundamental nature of copyright law, and this case illustrates it nicely in a context that's familiar to genealogists. So the second question on our list of 5 questions was, who owns the copyright? And this can be a tricky question, and it's counterintuitive in some cases. So we'll go through those. So first, as a general principle, it's the original author of the work who owns the copyright. And if in the case of joint works of authorship or collective works where you have multiple authors, for example, they might collaborate on in the music context, you often have a songwriter and a lyricist, a musician and a poet who might collaborate together, and the two of them would own the copyright together. There are some exceptions to that general rule, including this important one about works for hire. So if you work for a company, let's say that you were an employee of a movie studio or something, if you wrote a screenplay in the course of your dealings, then your work is covered. If you're a contact photographer, or if you're a journalist, there's another good example where you might work for a newspaper. All of your creative output is owned, and for the purposes of copyright, your employer is treated as the author. There's a very, very important exception for genealogy, though, that we need to be aware of. If you've commissioned a work by somebody who is not your employee, that is not considered to be a work for hire. So, for example, the photographer who came and took pictures of your wedding that probably was not your employee. They were an independent contractor, and unless you had some sort of written agreement in place with that photographer, the photographer is the one that owns the copyright. And wedding photos come up a lot in a family history context. So it's, nowadays we live in a digital era, and it's increasingly common for wedding photographers in this day and age to transfer the copyright and deliver their wedding photos in a digital form that couples can distribute however they want. But in an earlier era, it was more common for photographers to retain the copyrights, and if you wanted multiple copies of your photo, you had to order those additional reprints from the photographer. And as we'll see, that has some important implications later. Copyright can be transferred by an agreement or a contract, and this comes up frequently in the context of publication. So if if one of your ancestors wrote a book of poems and it was published by some publisher, there's a good chance that that ancestor transferred their copyright ownership over to the publisher. That's a very common scenario. Or like I said, in the photography context, you might have had a contract that would transfer copyright from the photographer to the subjects of the photo. Those are just some examples. There are other situations where you can transfer your copyright by some sort of agreement. But the principle is the same, that if the right has been transferred away from the author to some other entity, then that's the new copyright holder. Lastly, at the time of death, copyright generally transfers in the same way that other personal property would transfer. So if you own precious paintings or furniture, whatever other personal property you might own, the copyright can transfer in the exact same way. So you can, in your will, you can leave your copyrights to a particular heir if you want, or if you don't, if they're not named, they go into the estate and get transferred with the rest of the personal property as part of the estate. So when you're in the situation where you've encountered some work and you're wondering who of an author who has passed away, tracking down the current owner means going through the same general principle that you would use for any other property that ancestor might have passed along. So if they were survived by a spouse, for example, there's a good chance that their surviving spouse inherited 100% of the copyright. If they had multiple children, it might have been divided among children or grandchildren. And so you just have to look on a case-by-case basis to decide who the heirs are and who the current controller of the copyright is on a case-by-case basis. So we've talked about what is protected by copyright and who owns it. The next question that comes up is, how long does copyright last, or when does it expire? And this can be a very, very tricky question, especially in the family history context, as we'll see. The reason this is a tricky question is because, as we talked about at the beginning, there have been a number of copyright laws enacted over the years. And for our purposes, the two most recent laws are the ones that are most relevant. So we start with 1909, and in 1909, all works that were created enjoyed a 28-year term of protection to begin with, which could then be renewed for an additional 28 years for a total of 56 years of protection, possibly, under the 1909 Act. In 1976, we changed from a registration-based system to a lifetime-based system. So the way that it worked starting in 1976, well, really, the 76 Act took effect in 1978, but the way that it works is you look at the life of the author and then add another 50 years to that. This term was extended in 1998, the Soni Bono Copyright Term Extension Act, which added an additional 20 years of protection. So right now, for works that are created in the year 2016, the way that we measure the term of the copyright is we look at the life of the author plus another 70 years. So basically 2 full lifetimes. In other words, it's a long, long time before works are going to be entering the public domain that are created today. If you have a particular work and you're wondering whether or not the work that you're looking at is still protected by copyright, the best thing that I would recommend is that you consult this chart, which is published by Cornell University, which is considered to be the gold standard for determining copyright terms, because they can be very, very complicated. So on the next slide here, I've outlined what is in the public domain in the United States as of January 1st, 2016. So the way that these things work is every January 1st, works enter the public domain. So if a work was published in June of a particular year, it doesn't enter the public domain in June of the anniversary year. Rather, we wait till the end of the year, and it enters the public domain on January 1st of the following year. So this summary here represents works that are currently in the public domain as of today, and these dates will move on January 1st of 2017. So first we look at, if it's very important to decide if the work that you have in question was either published or unpublished. The rules are very, very different depending on whether it was published. So if it's a diary, a letter, these kinds of things that were personal and private, never published, it would fall into these categories. If it's a book of poems that was published, or a song, or something else that had some wider distribution, there's a different set of rules that apply. Okay, so as of January 1st, 2016, the things that are in the public domain are unpublished works of authors who died before 1946. Or if you don't know when the author died, there's a 120-year presumption, which takes us back to 1896. So if you have a work that was created before 1896, then that's in the public domain if you don't know when the author died. Obviously, if you know that something was created in 1893, but the author didn't die until the 1950s, then that isn't yet in the public domain. So anyway, that's for unpublished works. Now, if we turn to the subject of published works, if it was published before 1923, then it's in the public domain. So anything published before 1923 is in the public domain. If it was published between 1923 and 1977, remember the new law took effect on January 1st, 1978. If so, anything published in that from 1923 through 77 without a copyright notice, that's also in the public domain. There are some other rules in here. I just wanted to give a few different examples. In this slide, there are other things that could have been published without being renewed or not following certain formalities regarding the registration process. The topic we discussed earlier about not needing to register your works is true today, but under the 1909 Act, it was important that you register your works. So again, this can get really complicated when you're dealing with older works. And we had a question about the significance of the year 1923. And as you can see, basically you're looking for a publication before 1923. That's the significance of that date. If it was published before that date, then you're okay. So these are just some examples. If you have another specific use case, again, I would recommend that you consult with the Cornell chart. But I wanted to walk through a particular case study involving Anne Frank's diary, for example. The reason that this is an interesting case is because it's a diary that ended up getting published, so it's a little bit unusual in that sense. Most diaries don't get published nearly the same extent as Anne Frank's diary did. But as we'll see, the rules can be a little bit different because of where she lived. So she obviously tragically died in 1945. The diary that she had written was first published in the Netherlands in 1947. And 70 years after 1945 was 2015. So on January 1st of 2016, which is her life plus 70 years, her diary arguably entered the public domain in the Netherlands. It's important to note that that is the subject of some dispute right now. There's a foundation that is arguing that her diary should not be in the public domain, and that's working its way through the judicial system in Europe. But despite that, on January 1st, the full text of the diary became available immediately on quite a few websites in Europe. But here in the United States, the diary is not in the public domain and will not be, because for this particular work, we measure the copyright term based on the date of publication, and we add 95 years after the date of publication. So in the United States, this same work won't enter the public domain until the year 2043. And a US website which had originally published the diary, took it down because of this reason. They didn't want to find themselves in the situation where they were publishing something here in the United States that was not in the public domain here. I wanted to walk through this particular case study to illustrate just how complicated these things can get. So if you're dealing with ancestors from overseas, it just adds yet another layer of complexity. Again, I'd advise consulting the chart or perhaps even an attorney if you're dealing with a particular tricky case like Anne Frank's diary. Okay, so we've now walked through the subject matter that's protected by copyright, who owns the copyrights, and when they expire. If we're now dealing with a work that is protected by copyright and you want to know how you can use it safely without fear of getting sued for copyright infringement, we're going to talk about that next. The first bit of advice is, if it's possible at all, try to identify who owns the copyright and reach out to them and ask for permission to use the work. So this can be tricky, as we just talked about. A lot of things are protected by copyright that you may or may not have suspected, but if you are dealing with a photograph or a journal or some other, a song, whatever the case may be, and there's any possible way that you can identify who the copyright holder is and seek permission from them, that's the best, safest way to proceed. The next option, and we encounter this a lot when we're doing creative work. Depending on the nature of your project, you might be able to substitute a particular photo out for a free alternative. If you're just looking to do, a slideshow with a generic picture of a mountain, let's say, or some other landscape, there are lots of free versions of those kinds of images available through Creative Commons, and so that's another category of works that's available to you and is pretty low risk for you to use. The last category, if you can't get permission and you're not in a position to consider an alternative, you always have the doctrine of fair use, which we'll go through here in just a second. Fair use is a generic principle under U.S. copyright law that is intended to cover things like criticism, comment, news reporting, teaching, scholarship, or research. So basically, in the United States, we have a very strong tradition of free speech, and we feel like people should be allowed to comment on your work, or maybe even criticize it, or do research, and those sorts of things without necessarily getting your permission, especially if they're going to say something critical about your work. You might be unlikely to give them permission if you're the copyright holder, but given our free speech tradition in this country, we have the doctrine of fair use that covers that. There are 4 factors that need to be considered when you're doing a fair use analysis. The first is to consider the purpose and character of the use, including whether such use is of a commercial nature or for nonprofit educational purposes. The second factor is the nature of the copyrighted work. This basically goes to works that are highly creative in nature, so works of fiction like novels or screenplays or songs. Those are highly protected. If the works are more factual in nature, an algebra textbook doesn't enjoy the same amount of copyright protection here as a novel would enjoy, for example. Even though they're both books, one of them is more factual and another is more creative. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. So if you are quoting a small excerpt of a work, maybe just a sentence or two, or even a small paragraph out of a lengthy work, that's more likely to qualify for fair use than if you're relying on the whole thing or using the whole work. So photos, if you can crop out and just focus on the one ancestor that you have in mind, that might be a better case for fair use than if you were to capture a whole big group photo, for example. The fourth and final factor is the effect of the use on the potential market for or value of the copyrighted work. This obviously comes up most frequently in the context of commercial works, and so for genealogical purposes, the first and fourth factor usually are pretty favorable. If you're a professional genealogist and you're seeking to commercialize your research, then you may have a more difficult problem. But for the average user, if you're just doing research for your own personal uses, you don't have a commercial purpose behind what you're doing, the first and fourth factor of the fair use analysis are most likely to weigh in your favor. We're going to walk through another case study here. This one involves the J.D. Salinger letters. J.D. Salinger, as you may recall, was a very famous author, a novelist. His most famous work was The Catcher in the Rye. Shortly after he published that work, he became somewhat of a recluse. He just kind of didn't really spend a lot of time in social circles. And somebody wanted to write a biography of him, and it was an unauthorized biography. And so his biographer did quite a bit of research, and through the research efforts had come across some letters that J.D. Salinger had written to various people, and the recipients of the letters had deposited those letters with various university archives. So in this particular instance, the biographer went to those university archives, obtained the letters, through completely legal authorized means, and then sought to publish those letters in a biography that was not authorized by Mr. Salinger. So he sued for copyright infringement. And the publisher in this case, who wanted Random House, they wanted to go ahead with the publication. They asserted a fair use defense, arguing, again, we just went through those fair use factors, that they were just doing a scholarly research work on this famous person, Mr. Salinger. The court ruled in favor of Salinger in this case. And here's an excerpt from the opinion that I think summarizes nicely what the court had to say. The biographer who copies only facts incurs no risk of an injunction. He has not taken copyrighted material. On the other hand, the biographer who copies the letter writer's expression of facts properly faces an unpleasant choice. If he copies more than minimal amounts of unpublished expressive content, he deserves to be enjoined, which is exactly what ended up happening here. So, in other words, the court went through the analysis and stepped through each of these letters in turn and concluded that the biographer and the publisher had used more of the letters than they needed to use. Remember that third factor was the amount of the letters, or the amount of the work that was used in relation to the work as a whole. And so in this particular case, they felt that even though it was a scholarly work and it had some important social value, that when you balanced all four of the fair use factors, they especially in view of the unpublished nature of the letters and Mr. Salinger's desire not to have them published, this weighed against a finding of fair use in this particular case. So if J.D. Salinger happens to be your ancestor, then this particular case is especially relevant for you. But whether or not you have a famous ancestor like this, the underlying principle is the same, that the original author of a diary, a letter, they are the ones who own the copyright, and if you are publishing it, you need the permission of the copyright holder. Now, as we looked at before, you may be the copyright holder if you are the sole heir, so you don't need to get anybody's permission because you can grant the authority to yourself. But if the copyright holder is some other party, then you need to find out who that is and ask for their permission before you just proceed under the assumption that it's okay for you to go ahead and share or publish the previously unpublished letters or diaries of somebody in your family tree. Okay, the last question is, why do we need to worry about this at all? I suspect a lot of people who do family history work and haven't given much thought to copyright issues, and maybe they're thinking that this isn't really that important to begin with. So in answer to that question, there are a few things that I think need to be borne in mind. First of all, copyright law has pretty severe penalties, both through civil fines and potentially criminal penalties for infringement. If you think about big content industries, movie studios and recording studios, they've lobbied Congress pretty hard over the years to stamp out piracy, which are a major threat to their industries. And through their lobbying efforts, they have successfully obtained very, very stiff penalties for piracy. Now, obviously, that's a very different context than genealogical research, but the copyright law is the same. And so, you have to bear in mind, whenever you're doing something that's arguably copyright infringement, you are subject to that same set of laws and could potentially face those same penalties, which in the case, just to give a sense of scale here, a single act of copyright infringement, if it's willful, can be punished by a fine of up to $150,000. And we have a few instances where the recording industry in recent years has sought to make examples of college students who have a certain reputation. We're here at BYU. College students have a certain reputation for not being terribly compliant with copyright laws, and we've seen some examples recently where college students have graduated with a lovely judgment against them in $600,000 or $700,000 in damages, which is a great way to begin your career as a young college graduate. So it doesn't happen to everybody, it doesn't happen often, but the penalties are there, and it can be a very serious matter. Another thing to bear in mind is that family history has changed quite a bit. When I was a young man, family history happened in big ledger books that were books of remembrance, and grandma or somebody would go up into the attic and dust off some old photos and bring them down, and you might make a copy and give them to a few people, and you'd put them in your book of remembrance, and that was that. Nowadays, modern family history happens online. Everybody is sharing and uploading and copying, and because your book of remembrance is most likely sitting out in a public forum, a copyright holder can find it, and in a way that would have been very difficult years ago. And so, as a practical matter, the risk that you as a genealogist incur by publishing photos or text or music is significantly higher in the year 2016 than it was, say, 20 or 30 years ago, where you might have just tucked that away in a book that rarely saw the light of day. And you should also be aware that these content holders are becoming increasingly sophisticated at finding this stuff. There was a recent news article, for example, that Google, who owns YouTube, the largest user-generated content platform in the world, in the month of February of 2016 alone, they received 76 million copyright infringement notices. You did hear that correctly. It's 76 million in 1 month. It's a staggering number, but it just goes to illustrate that content owners are actively policing this stuff, and it's increasing. And even though we haven't seen a lot of cases coming through genealogical websites, this is something that we should be paying attention to. For those who are members of the Church of Jesus Christ of Latter-day Saints that may be listening to this, there are some articles of faith that that we should probably bear in mind. One, that we believe in obeying and honoring and sustaining the law, and we also believe in being honest. These are attributes that hopefully we can exhibit in our own personal lives, even though it may require some additional work and effort on our part in this area. There may be a lot of people around us who seem to disregard these rules or laws, but that's not the standard to which we hold ourselves. If there's a set of laws, we believe in complying with those and sustaining those laws. Again, I'm using family search agreements as just one example. These are typical of other genealogical websites. Hopefully, most of the folks on this webinar are familiar with these agreements, but I just wanted to highlight, when you upload any information, whether it's a photo or any other type of file, text, you certify that you either own the copyright yourself or that the work is not protected by copyright. So this is the same process by which other user-generated sites that host user-generated content, so sites like YouTube, for example, have the same sort of certification that everybody who uploads content to these sites, they're all certifying that they have personally done the copyright clearance and searching before uploading. So you should bear that in mind before you just hit right-click, save as, and then the upload button, that you need to know pretty much any reputable website is going to have a similar restriction, and you personally are the one who bears the burden of doing the research necessary, contacting the copyright holder if needed to secure the necessary permission. The final case study that I wanted to look at, for those of you who may be thinking, we've looked at some interesting cases, but none of them seem to deal directly with genealogical materials. Again, for the members of the LDS Church who may be listening, the church itself, which is a well-known participant in family history and has been for many, many years, found itself on the receiving end of a copyright infringement lawsuit about 20 years ago. So in the mid-90s, in this particular case, what had happened was a group of folks, the Hotalings, I believe is how their name is pronounced, they had compiled some genealogical research materials that they made available in microfiche and marketed commercially. The church purchased one copy of these materials and put it in the main collection at the Family History Library in Salt Lake City. They then proceeded to make additional copies without permission and sent those copies of the microfiche to various branch libraries. And then when this activity was discovered, the church had those additional copies recalled and destroyed from most of the branch libraries. At some point in all of this process, the one authorized copy that the church had purchased somehow became lost or destroyed, and it was replaced by one of these unauthorized copies that they had made. And that's the copy that was left at the main Family History Library in Salt Lake. So patrons could come into that library. It wasn't available anywhere else, and it was a microfiche. It had to be used in the library. It never left the premises. And so the church's perspective on that was that did not constitute a distribution of the copyrighted content, because it was limited to use in that one building, and the church had purchased one copy. Hotaling saw that case a little bit differently. They sued for copyright infringement, and the court ruled in favor of the plaintiff in that case. So again, this was it wasn't a good outcome for the church in this particular case. This was the holding of the court. When a public library adds a work to its collection, lists the work in its index or catalog system, and makes the work available to the borrowing or browsing public, it has completed all the steps necessary for distribution to the public. At that point, members of the public can visit the library and use the work. So if you think about that quote, again, that's from the mid-90s when we were doing this on microfiche. That same principle applied to what's happening on Family Search now or other genealogical websites. When you upload any kind of work, whether it's photos or music or any of that sort of thing, text, it's pretty clear that you're doing that the same principle would apply to that situation, that you're making the work searchable, it's available to members of the browsing public, and so it would constitute copyright infringement if it has not been authorized. So, while most of copyright infringement tends to happen in more commercial settings, movie studios and recording studios and those kinds of things, it's not unheard of for there to be litigation in the area of genealogy and family history work, and so it's important that we keep that in mind. This is the bonus section at the end, some 4 common copyright myths that we're going to hopefully debunk here. If the first one that we hear a lot is everything that you find on the internet is in the public domain. As we saw before, this is just flat wrong. The public domain does not encompass everything that people have posted publicly. Rather, the public domain encompasses things that were published a long time ago, or were never published and the authors passed away a long time ago, or if we don't know when the authors passed away, that they were created more than 120 years ago. So most of what you find on the internet probably is actually protected by copyright, despite what you may think. Even though it's easy to right-click Save As, does not mean that it's legal to do that. Another myth that we hear is, as long as I cite the work correctly, I don't need to get permission to use it. That's also wrong. That myth confuses the issue of plagiarism with copyright infringement. Plagiarism is when you try to pass off somebody else's work as your own. That's not really a copyright issue. That's more of an ethical honesty type issue. Copyright infringement is about getting permission to use the work. So even if you openly advertise, hey, I'm using somebody else's music in the background of my cat video on YouTube, but I don't intend to infringe anybody's copyright. So none of us are confused and are thinking that that's you singing. You still need to get permission from the original songwriter and a recording artist, and that's the difference between plagiarism and copyright infringement. Another misconception is, well, once I've purchased a work, I can make lots of copies of it. After all, I paid for it. As we saw in the case we just looked at, the church purchased a copy of the work and absolutely was not authorized to make additional copies. That's the most fundamental right of copyright infringement. You don't necessarily get a license just by physically owning an object to make additional copies. This last one we hear a lot, certainly in academic circles, but sometimes in other cases too. Something about fair use allowing up to 10% of a work to be copied. That's, again, just wrong. The courts have very, very consistently indicated that their fair use involves a careful balancing of all 4 of those factors that we looked at earlier, and it does not lend itself to mathematical or arithmetic approaches like bright lines like 10% or 1 minute of video or whatever the case may be. Whatever you might have heard to the contrary, you should know that that whatever you've heard is just an old wives' tale. It's just a myth. And the truth is, when you're doing a fair use analysis, you need to look at all 4 of the factors, carefully balancing them, like we saw in the Salinger case, and making sure that in the end, that once you've looked at the purpose of your use, the nature of the work, the amount that you're using, and the effect it has on the market as a whole, that the use is considered fair. Okay, I've lastly provided, this will be in the materials, just a list of additional resources where you can go to learn more if you want to be more informed on copyright issues. The first is the website of our office here at BYU. We have a lot of additional resources on fair use and a number of other areas. The U.S. Copyright Office actually has quite a bit of good training materials and background information. Creative Commons, which I mentioned earlier, is a terrific source of free content, and so you can see them at creativecommons.org. the Cornell chart, there's the link to it if you want to look at that. There's also a handy book, which I used somewhat in this, written by Sharon Carmack, and it's available here in the BYU Family History Library, or you can find it on Amazon. And it's a specific guide for copyright in the context of genealogy, so it's a good resource as well. Finally, I wanted to provide my contact information for anybody who wanted to reach out for additional questions. Feel free to email or call our office. The information is there, and we'll be happy to help you if we can, and take any specific questions. I think that pretty much wraps it up, and so thank you for listening, and I hope this was helpful, and if we can be of help, I look forward to hearing from you.